In a world where there are generally more questions than there are answers, there is one thing I can be sure about. Jesus definitely had more hair. That, and if you stare at this photo long enough, you might just get the meat sweats. According to the Boston Globe, the Norfolk DA's office has the lowest homicide clearance rate among state police, which in other words means they've solved fewer unalivements in the last 9 to 10 years than this Texas cop has issued speeding tickets in the last 48 hours for not getting her freak on in a Walmart parking lot during her lunch break. Hello, and welcome back, roommates, to another titillating edition of Alexa's Room, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people who have opinions about all things going on post Karen Read verdict, including the Norfolk DA's office falling short in more than their selection of spiced meats. Yes, according to the Boston Globe and homicide investigations, one state police unit falls below the rest. Womp womp, but still outperforms most U.S. investigators. That's a terrifying thought. Judy Rodriguez keeps photographs, candles, and flowers at the spot outside her home in Braintree, where her 16-year-old son and another teenager was shot to death. 2 years after that night, she's still waiting for answers. I want them to get to the bottom of this, Rodriguez said. I want to rest easy knowing that we caught the people who did this. I want them to do their damn job and not drain the taxpayers of all of their money persecuting a factually innocent woman and putting all your resources and energy and time into that. But okay. The unalivings of her son Jazir Les Porter, I hope I said his name correctly, and Jaden Santos Andrade, who was 19 at the time, are among 10 unsolved unalivings under investigation by the state police unit attached to the office of Norfolk District Attorney Michael W. Morrissey. The same squad in the two controversial investigations of Karen Read and Sandra Birchmore. Remember when Morrissey announced that he stands by the medical examiner's ruling on Sandra Birchmore's death as a self-unalivement? And while Morrissey's office has a high rate of resolving homicide cases compared to the national average, it trails its state police peers in Massachusetts with the lowest clearance rate of unalivings among the state's 11 district attorneys. Investigators in Norfolk County solved 82% of 57 homicides. Not a lot if you're looking at a big city like I imagine Boston, right? New York City, LA, obviously. Heck, Nashville I'll throw in there. Vegas, right? Where there's a lot more people. It's a lot more populated. A Boston Globe review of cases between 2015 and 2024. So, I mean, again, it's comparing apples to oranges here. In Massachusetts, homicide investigations in all but 4 cities are handled by state police units attached to the local district attorney, an elected position. So again, if you're going to go out and vote, folks, again, not everybody's down to vote for the presidential election, and I'm not here to tell you what to do or not to do, but if you want to see a change in your community, that's the best time to put your money where your mouth is and get out there and vote at least locally. Homicide clearance rates at the other state police squads range from 88% at the Essex and Plymouth district attorneys to 91% or higher in the remaining offices, the Globe found. So Plymouth and Essex are kicking Norfolk County's buttocks. Combined, the state police units at the 11 offices had a clearance rate of 92% for the 848 homicides they investigated during those years. So 848 homicides collectively from 2015 to 2024. Again, comparing that to some of the largest cities in the country, you know, that's peanuts. And to make this distinction, clearance in this circumstance means a case has been solved, though it does not mean there has been a conviction. All of those results are much higher than elsewhere. The average nationally hovers around 57%. The clearance rate in Worcester, one of the 4 Massachusetts cities that conduct their own investigation, was 71% from 2015 to 2024. Rates for the other 3 cities, Boston, Pittsfield, and Springfield, were not immediately available because I'm sure, again, there's a lot more people in Boston than there is in Norfolk County. Morrissey's office declined to make him available for an interview, which, no surprise there. In an email, a spokesperson, not David Traub, said its homicide clearance rate is well above the national average and in line with the district attorneys serving similarly sized populations. So the Boston Globe's data to back up their claim of Norfolk County outperforming the national average is just based on the spokesperson, the hired mouthpiece, who's supposed to say good things about the office that he's spewing his gob about. That's your resource, instead of actually pulling real numbers before publishing this article. While Michael Morrissey is not available for comment at this time, if you would like to book an appearance with him, he is available for Sweet 16s, bar mitzvahs, hostage videos. Oh yes, and our upcoming fall festival, where I heard there will be finger painting, sponsored by Aperture. State police consider cases solved or cleared if investigators make an arrest, obtain an arrest warrant. Well, we know that they kind of struggle in that department, or can determine the responsible party with certainty, an agency spokesperson said. So are we hearing from 2 different mouthpieces? I'm confused. State police said the investigation into the fatal unalivings of Porter and Santos Andrade is active. Some relatives of the victims also kept tabs on Karen Reed's case as it wound through the courts, which is smart because, again, it's like if you're pulling this kind of shiz to a white woman who's financially successful, single, good-looking, what are you possibly saying about everybody else, right? Porter's father, Les, said he sought a meeting with detectives last year after Chip, the lead investigator in both his son's case and the retrial, was suspended over misogynistic texts. He wrote about Reed. It was more than just that, but yeah, let's just play the misogyny card, right? It's a softer blow, ironically, than the other stuff he got suspended over, which became a central factor in her trial. Proctor was ultimately fired, as we know, and he's currently fighting to get his job back, which I find is difficult probably to do when you're too busy bumping coconuts with Cabana Boys singing Barry Manilow. I am the father of a child that was unalived, Les Porter said. I wanted to make sure Proctor was no longer on the case, and I wanted to meet the new person who was. I'm curious who that new investigator was, and as more information hopefully progresses with these cases, I'll keep tabs on that. What do you tell parents like this? What do you tell victims' families like this? I mean, it was only recently that Enrique Delgado Garcia's family was able to start seeing some movement in his case. His case has finally been brought in front of a grand jury. Now, whether or not that case moves on to some sort of indictments for whatever responsible parties are going to be prosecuted, we'll have to see. But the same day that this was published, Turtle Boy announced on the Billy Bush show that Karen Reed is going to be bringing forth a federal lawsuit against the MSP.
But what they should be worried about, though, is this lawsuit that's coming that Alan Jackson kind of alluded to. And I can confirm that Karen Reed is going to be suing the state police in particular amongst others, in federal court for their involvement in covering up and framing her for murder.
Yeah. That's what Alan was referring to. So there's some people in the comment section here going, I'm scouring everywhere. What are you talking about? He did allude to, hey, I told you we weren't done. We're not done. So Karen is going to file a federal lawsuit against Massachusetts State Police. That's going to be a big one. Boy,
Yeah.
what a scene that will be.
Yeah, obviously there's a lot of hurdles to overcome because of, there's immunity, like every defendant would just sue anytime they were acquitted, right? But she's got a really strong case for it.
And tomorrow morning, Alan Jackson's going to be hopping on the Greg Hill show, so I will be tuning into that as well. And if there's anything, any news or updates from that, I will be sure to report here. But this is all likely why. So while all of this is going on, and I guess this Boston Globe article in part was kind of a coordinated puff piece in a way, of saying like, oh, hey, our office is bad, but we're not that bad. We could be so much worse, right? I mean, just look at the national average. Look at other major cities. Compared to LA, we're like Candyland. We're like Disney World over here. So, and this is likely one of the many reasons I can imagine why Adam Lally is suddenly getting cold feet about hitting the stand again tomorrow. And why your boy is sweating more than Meatball Morrissey at an all-you-can-eat buffet. Shout out to Meredith O'Neill on the Twitter X's for sharing this motion that was filed today by Team Adam Lally. This motion to limit the scope of questioning of attorney under subpoena. On May 28th, 2025, the defendant in this matter filed a motion to dismiss or, in the alternative, release on bail and continue the trial date, given the voluminous late disclosed evidence brought to you in part by Adam Lally and Chip. And this is regarding the Myles King case, because remember, Adam Lally is supposed to be bright-eyed and bushy-tailed for tomorrow's festivities. After that motion was filed, the parties jointly requested that the court continue the trial date and reduce the defendant's bail to $2,500 with conditions, but it was ultimately upped to $10,000. Myles King was able to make that bail, and now he has since been released on bond. The defendant posted it on June 27th, 2025. So he's been out for a couple months now. So in other words, after last time's pick roast, brought to you in part by one Rosemary Scapiccio, it appears that McLovin is looking to play hooky from court tomorrow. The court should suspend Lally's testimony unless and until the defendant makes a preliminary showing as to all three required prongs required for dismissal. 1, egregious government misconduct. I think holding on to 200 plus pieces of evidence from disclosure would count as egregious, but all right. 2, prejudice to the defendant's right to a fair trial. And 3, a showing that dismissal is the only remedy for the prejudice. Again, this guy was locked up for 4 years without any of this stuff being disclosed to his team. So I don't know what else you would consider prejudice to the defendant's right to a speedy, not only just a fair trial, but a speedy trial. The hearing on the motion, now addressing only a motion to dismiss since the trial date was continued and the defendant was released on bail, was scheduled for July 21st, 2025. Assistant District Attorney Adam Lally was issued a subpoena by defense counsel to appear at the hearing in this matter, scheduled for July 21st, which we did a video on. If you missed that, I will link it in my show notes. He appeared and began testifying over his attorney's objection, right? So before he took the stand, his attorney asked the judge, hey, he shouldn't have to take the stand. He's happy to do this behind closed doors, yada, yada. And Krupp was pretty much I don't care how bad this looks, to the DA's office. Like, he should be able to take the stand like any other attorney who's been subpoenaed before. Because attorneys get subpoenaed. Law enforcement agents get subpoenaed to testify all the time in court. And Lunchbox ain't no exception to the rule. So get his butt in this chair and wipe the glue off his snout. And let's go. Let's get ready to rumble. At the hearing, the court directed counsel for the defendant and the Norfolk DA's office to work together to specifically identify the scope of discovery that was disclosed late to the defense. Remember, he had that list. He was checking it twice. Didn't know if he was being naughty or nice. The court also directed counsel for the defendant to review the materials and to identify specifically any exculpatory evidence that was disclosed late to the defense. Most importantly were the bare minimum basics, like there were crime lab reports, there was a witness apparently who died before they could even speak to him, before they were even made aware that this person existed, I believe. Jailhouse call recordings, of course, the search warrants, that was a big thing that Proctor wrote up, and they didn't even have any of this stuff that they put forth for the grand jury, from my understanding. Lally testified on June 21st, yada yada. Hearing was continued until tomorrow, with the expectation that the parties would have narrowed the scope of discovery at issue, and counsel for the defendant would have identified what she claimed to be exculpatory and prejudicial. Well, the defendant is Myles King, and Rosemary Scapicchio is the attorney for the defendant. So I think you mean defense. Before McLovin's testimony recommences in this matter, counsel for the defendant should comply with the court's directive and identify how the evidence at issue here is exculpatory. Well, that's exactly what she was in the middle of doing. And then they had a hard stop at like 11:30 a.m. or something. So I'm assuming that's what tomorrow's continuation is going to entail. Put up or shut up, man. And how the defendant has been prejudiced, particularly given that he has been released on bail and the trial has been continued. Yes, but he was sitting in jail for 4 years. But two of the requirements for dismissal under Commonwealth versus Trapania, the defendant's motion fails and testimony from Lally becomes unnecessary. I think it's completely necessary. He was the prosecutor at the time before he passed things over. Should the court still wish to hear from Lally, we, the undersigned counsel for him, respectfully suggest that his testimony should be strictly limited to the issue of whether his conduct constitutes egregious misconduct, which, in light of the 26 notices of discovery providing unique discovery each time, certainly does not. 26 notices of discovery seems pretty egregious to me, in my opinion. I'm just saying. And again, this guy was chilling in a jail cell for 4 years. If any of this stuff didn't come out with Karen Reed in her case, and this light wasn't being broadcasted to millions and millions of people, he'd probably still be sitting in that jail cell, no bond, in my opinion. This case is worth a close study, because the court has nothing better to do than the night before we're all supposed to get together and do this thing. Like this case, it emanates from an allegation of late disclosure of evidence that was ultimately disclosed pre-trial. So essentially what this guy is saying here, better late than never. And hey, the trial got continued anyway, so technically we're still in that pre-trial phase. In that case, the trial court issued an order to produce the discovery, but included that what should have been excludable time under Mass R, yada yada, ultimately leading to dismissal. The appeals court was clear that dismissal of the charges as a sanction for a violation of yada 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 in the absence of a finding of irremediable harm was an abuse of discretion. In footnote 8 of the decision, the appeals court acknowledged the 2025 amendments to Rule 14, including the sanction provisions. We discern no substantive, I'm going to say substantial, because that makes more sense in my brain, no substantial change in this language. Rather, we think it merely provides an illustrative list of sanctions to aid litigants and judges. A dismissal with prejudice under Rule 14 still requires a showing of irremediable harm. In order to warrant dismissal, there must be egregious prosecutorial misconduct and prejudice to the defendant's right to a fair trial, and dismissal must be necessary to cure the prejudice, yada, 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 yada. Where the defendant has not made a preliminary showing as to all three components required under Commonwealth versus Trepigna and Commonwealth versus Edwards, the case cannot be dismissed. The remedy is a mysterious. This is all right, enough of that. Of dismissal is only warranted when there is egregious government misconduct, prejudice to the defendant's right to a fair trial, and a showing that dismissal is the only remedy for the prejudice. But again, I believe this is all what we were trying to figure out here. Like, we were only halfway there, living on a prayer, right? You gotta let her finish the song. Right? There's a key change. There's more harmonies. It gets very climactic at the very end of that song. And she was hardly halfway there. In this case, should counsel for a defendant fail to identify for the court how many of the documents at issue are exculpatory and therefore the late production prejudiced his right to a fair trial, and where counsel for the defendant failed to show how dismissal is necessary to cure the prejudice given that the trial date has been continued and the defendant is released on bail, which again, they're like, well, hey, he's out, so like that, who cares, right? Who cares? The defendant's motion can be denied without further testimony from McLovin. In any event, McLovin and his testimony should be strictly limited to the issue of egregious government misconduct. The court will allow that Attorney Lally was diligent, well-meaning, and that his conduct aimed to conform with his obligations as a prosector. Adam Lally, Esquire. Pat Hanley. Well, I guess that speaks volumes, right? When you're being repped by a law firm that goes by Butters Brazilian LLP, where we believe in a full bush defense and every closing argument ends with a happy trail. And with that being said, if you enjoyed today's content, make sure you hit that subscribe button, make sure you hit that notification bell so you do not miss the next video from me, and make sure you hit that like button because that tells the YouTube algorithm that this is newsworthy news, and it is. Hopefully, all this exposure, all those wrongs get righted, right? That is the whole point of this. Don't want to be cynical and continue to just be on a misery fest. We want things to improve so that your life can get better. Thank you so much for watching, and until then, don't put Nair on your face.
I decided to put Nair on my face because when I have an exfoliated face, it pisses the Caroline off, whoever's living in my face. Just right here right now and right here.